Hi, everyone. Today is Monday, June 29th, and the summer's going by pretty quick here. I wanted to put up another video. Unfortunately, I am in Lowell, Massachusetts every day this week, um, lecturing faculty on how to be better professors in a traditional life class. So I'm exhausted from all the driving and have to talk to your peers. It sometimes can be a little intimidating, so I'm kind of emotionally drained. But I don't want to fall behind, at least on the lectures. I might fall a little bit behind on grading some of the homework. And again, I want you to take it seriously that you do not have to take the quizzes until I give you feedback on the homework. Unless you're way behind in the homework, you're going to have to step it up a little bit on that. But, hey, you say you did your homework on time or reasonably on time, and you're about to take a test. I said, geez, I didn't get any feedback on Jim on this homework. I wish I had, because that's how I want to do, how I'm going to be able to assess whether I can do well in the exam. So don't be afraid to postpone that out. I'll leave the test open for a lengthier period of time, especially during this week and a half craziness I got going on. Chapter 11 is kind of a nice chapter for those of you that started a business law class and thinking about the heart and soul of business being contracts. Most of you came in with this preconceived idea that a contract has to be in writing. Right? If I know in my live tradition brick and mortar classes, I have students and I always say, what does it have to be a contract on the first day, just to kind of get sort of the juices flowing and the conversation going about what contracts have to be. Most people say, well, you have to have a writing and it has to be signed and maybe it has to be witnessed. And some people think it has to be notarized. What you already know from the early chapters is that most contracts can actually be oral, just spoken. Right? And that's an express contract, as the terms are overtly stated, or at least enough of the terms are overtly stated so that we know we have a serious offer and an acceptance on those same terms. And we know some contracts can actually be entirely implied. It's rare, but we can know by the behavior of the parties in their implicit consent to be bound by certain kinds of obligations. But there are obviously, and I alluded to it earlier, and I think the syllabus does, and the book certainly does, that some contracts have to meet a certain form. I'm not going to go over every one of them because I don't know every one of them. You'd have to be an encyclopedia to know every time the legislature's gotten together and said these kinds of contracts need to be in writing to be enforceable. This is an introductory class, and I can tell you the core ones are in the book, and the core ones in the book, I wish they used the acronym I'm going to give you right now. I don't expect memorization. It's an open book exam. I usually give open book exams in my traditional brick and mortar class because I want you to know the principles behind the concepts more than rote memorization. But this one's fun in the sense that you can remember it by the acronym MyLegs. These contracts have to be in writing to be enforceable. That means if somebody's resisting enforcement, you have to be able to pick up a piece of paper and say, that opposing party has signed this written agreement or memorandum, and therefore they're bound. Both parties are always free to go forward, even if it's just an oral contract, even though the law says in this area to be enforceable, it has to be in writing. It's only when someone's resisting going forward that we care about the writing. So one of them, for example, is goods over $500. So if I go and want to buy a snowblower from you and you say, I want $1,000 for it was $1,500 brand new, and I say, I'll offer you $1,000 and you accept. And I say, okay, I'll come back tomorrow with the money. The next day I come back with the money and you hand over the keys to the snowblower and physical possession and I give you the money. Did we ever reduce anything to writing? No. Is the contract valid? Yeah, because it's been executed. We only care about the need for a writing during the executory stage and if and when someone decides they say, I'm not going forward with this obligation. I'm not admitting the existence of it and I'm going to resist enforcement. That's when the requirement of a writing is necessary. Otherwise, we don't care about it. So what are they? MyLegs. That's the acronym. MyLegs. MYLEGS. Those are the core types of contracts that need to be in writing. So what does the M stand for? Contracts related to marriage. You're not going to be so concerned about that for business law. So these are prenuptial agreements, and they're also separation agreements. The law requires that either of those kinds of contractual obligations must be in writing and signed by the parties to be enforceable. We can get to this point a little later. Both parties don't actually have to sign. That's going to throw a lot of you off. What do you mean? Of course you want both parties to sign. But think about it. If I come up to a written agreement with you and you sign it, as long as I'm willing to go forward with it, we don't care about the fact that my signature is lacking on the document because I'm willing to comply with it. It's only the party that's resisting enforcement that we actually have their signature on it. Because think about it. What if I had a contract with you for that snowblower that we talked about? It's for $1,000. We reduce it to writing. You sign it as the seller of the snowblower. The next day I come to pick it up. You refuse to go forward. Well, if I want to enforce that written contract, what could I do literally that day or the day I actually entering into the trial? I could sign it right then and there to show my intent to be bound. It's the party resisting enforcement that we want their signature. But for practical purposes, what do you always want to do in business? Make sure both parties sign the agreement. So there's none of this debate over that nuanced question of which party has to sign the agreement. But you do know for the test, if it's on the test, and it probably is a very good test question, do both parties have to sign the contract? No, only the party resisting enforcement of the terms of that agreement. So marriage, contracts related to prenuptial agreements, very romantic. I'm crazy about you. I want to be with you forever, but just in case, let's predetermine what we're going to do with our assets. That has to be in writing and signed by the parties. And divorce settlements, most cases that when people go through divorces often come to a settlement, whether months or weeks before the trial or even during the day of the trial. They have to usually come up with what we call a separation agreement, and those are contracts. And they're fully enforceable in law as long as they're not unconscionable, and they can't delve away with child support obligations. This is about division of marital assets and things of that nature. I'm not going to come up too much in business. Some of you are interested, so I thought I'd talk about it. The why, that one's important for business. The why in the acronym MILEG stands for contracts that by their nature must take a year or more. So the why is the year. So if I hire you to be a lawyer or a paralegal in my office for a 3-year term with, say, staggered pay for each year, incentive pay, all kinds of different things, and we don't reduce that to writing, I can't sue you if you leave after the first year. I can't say, well, wait a minute, Sue or John, we had an agreement that you were going to work for me 3 years with this rate of term, and you know it's true. I have you on a video. Doesn't matter. We never reduced it to writing. And the contract by its terms was a 3-year contract, so it's not enforceable beyond that 1-year term. So a baseball player, for example, they signed a 4-year contract with the Yankees. In order for that contract to be enforceable against the Yankees and the pitcher, or baseball player, I don't know if I said pitcher, but the baseball player, that would have had to been reduced to writing because there's no way they can complete that in less than a year. It's a 4-year contract. This trips people up, though, when you say things like, the Mount has me as a permanent employee. Well, that must have to be in writing. It is, but let's assume it's not. Would that be now unenforceable under the statute of frauds? No, because if it's a permanent contract, could a permanent contract be completed within 1 year? Yeah, I could pass away within 1 year. I could decide to retire within 1 year. It's not necessarily going to be taking more than a year to complete, even though it's likely to. Same as what if the Mount decided to build dorms on the campus? It's going to take a long time to build dorms from beginning to end. Would that contract have to be in writing? The Mount hires some big construction company, and it's going to cost $30 million to put dorms in for 400 students. Would that have to be in writing? It should be. It helps to prove what the party's intent was, and we know each other's bound by if you reduce it to writing. It helps for proof. But would it have to be in writing under this 1-year rule? So I'm going to say, yeah, there's no way they're going to build dorms within 1 year from beginning to finish. But could it be imaginable that it could be finished within 1 year? Yeah, it could be imaginable. It's not going to happen, but it's imaginable. So therefore, that contract, believe it or not, it's for $40 million, would not have to be reduced to writing under the year rule. But if you hired a custodial company to take care of those dorm rooms at the Mount, mow the grass around, keep the windows clean, in the bathrooms, in the common hallways and things like that, but you hired them for a 5-year term. Well, there's no way they can fit that 5-year term into 1 year. That contract to be enforceable between the two parties would have to be in a written form. And there's not a lot of language in there, just enough like the original offer and acceptance we were talking about in the previous chapters, just enough of what the parties were talking about. Give me handwritten, preferably in ink. Some jurisdictions sometimes say it can't even be in pencil because it's too subject to fraud. In fact, that's what this chapter is about, the statute of frauds. We're concerned that these kinds of contracts, because of their importance and often their value, are often ripe for fraud. And so way back, I think it's 1677, I came close, 1677, over in England, they established the first statute of frauds, this recognition that because these contracts were often lied about and people are trying to be placing other people in a form of a binding contract by just saying it happened. Imagine that. Hey, you said you'd do this for 5 years for me. I'm like, I didn't say do it for 5 years. Imagine if a court held me bound because of the other person's allegation. I'm going to say now, because it's important in terms of time, marriage. Right now, we're just talking about time and marriage, M and Y right now. The law says because of the statute of frauds. It sounds fancy, but when you think about it, it kind of makes sense. It's a statute designed to deter fraud. And what can deter fraud? having the parties write down their obligations and sign them. The next one of my legs is land, and that might come up in business quite a bit. Anytime you buy an interest in land of any kind, easement, right of access, ownership is the one I'm really thinking about here. It has to be in writing to be enforceable. In some jurisdictions, leases more than 1 year have to be in writing. Well, the 1 year rule kicks in, so it does. Has to be in writing, but that's not land. But generally, an interest in land to come an owner in some kind of type of estate in land, fee simple, which is what we think of when we buy a home. That contract, when you go to buy that home, has to be reduced to writing and signed by the seller, and hopefully the purchaser too, to bind the parties. Otherwise, you can walk away. And that happens a lot. I do a little bit of real estate stuff, and sometimes you initially talk on the phone, and and you say, "Well, geez, my client, really likes a house, but 400 is just way too steep. You guys you're out of your mind. But my client's willing to make an offer of 350. I'll call you back in a couple hours. Sometimes next thing goes, you know what? The seller will take 350, especially if your client has it. Can close in 30 days. And he goes, yeah, we can close in 30 days. We got a deal? Yeah, we got a deal. It's not enforceable yet. Why? Because it's oral. Contracts for the transfer of legal rights within real estate have to be reduced to writing to be enforceable. That doesn't mean we can't still go forward just because we didn't reduce it to writing. We can write something up and still transfer the deed even when we never had a written contract. Be foolish not to. But my point is, this is only if somebody's going to resist enforcement that we care about. So we got marriage, contracts for a year or more by their terms, contracts for any interest in real estate. That's the next one. The next one for my legs is executors' promises. These are executors and administrators that take care of a decedent's estate. It's very narrow. It's not going to go too much in business, but you might be a wheeler and dealer, and you might be able to get a good deal from an estate. And so you might get a promise from someone who's taking care of a decedent's estate. Say my brother croaks, and I become his executor, and I'm going to sell some of his stuff. Or I'm making promises to pay some of his bills to you. I find out he owed you some money, and I promise orally to have those bills paid out of my brother's stuff. Now, all of a sudden, I have second thoughts about it, and I said, geez, my brother had other obligations. He's got daughters. I want to make sure they're taken care of. I'm not going to pay those bills. I don't think they're really legitimate. And then the other side can't come up and say, but Jim, you as the executor of your brother's estate promised to pay those debts. If that was not reduced to writing and signed by me, it's not enforceable. And the reason why I think the law, I never really studied this historically, but I was always fascinated by it. And I'm always curious, why do we have these rules? With this, I think there's a lot of situations where people are working for a decedent's bills and contracts and trying to resolve outstanding obligations. And sometimes there's emotional pressure, and sometimes there's lack of knowledge about the nature of the underlying starting points of these cases with the decedent. And so in order to really have this be binding upon the executor or administrator, they're really the same thing. One's when there's a will, one's when there's without a will. Those people shouldn't be obliged to follow through on those contracts unless they've taken the time and wherewithal and thought to reduce it to writing and signing. Because we do. When we think about it, when you agree to stuff, sometimes you do it sort of flippantly, orally, but you're a little bit more cautious when you reduce things to writing. What exactly am I paying, and why am I paying for it? Or what am I buying? You reflect a little bit more careful. So so far in my legs, we've got marriage, contracts for a year or more. Then we have land or any interest in land. Now we have an executor's promise to basically pay the debts or enter into contracts on behalf of decedent's estate. The next one's a big one for business. It's probably the biggest one of the statute of frauds, in my opinion. And it is goods over $500. And what's a good? Any tangible, movable things. A house is not a good. A house is real estate. That's under a separate set of laws, but covered in business law a little bit. But I'm talking about specifically goods. My computer right here that I'm flopping around, that's a good. My printer up here is a good. My briefcase is a good. That ironing board over there is a good. I'm not going to show you because there's a horror show over there. This secretarial desk is a good. That weird lamp is a good. It's movable. It's identifiable. It's a tangible thing. Now, contracts for most goods do not have to be in writing to be enforceable. In fact, the only ones that have to be in writing to be enforceable are goods that are over $500. But do we often enter into transactions and never have a real written contract for goods over $500 all the time because both parties are willing to go for it? So when I bought this phone, I don't think I paid. I think when I paid with a debit card, I had the money saved up. I bought the iPhone. I went there. I never signed any contract. I never filled any contractual information because Apple did not. I bought it at the Apple store. I didn't, I have the Verizon as a carrier. I just bought the phone. I didn't sign a contract. They didn't sign a contract either. it was irrelevant. Why? Because both parties executed. It's only if I had a promise from them to sell it to me next month, and I had an obligation in my promise to buy it from them next month, both of us could have walked away from that obligation because neither of us wrote it down or signed it. You get it? So it's only important for executory contracts. That's why we need to know those terms from the earlier chapters. Now, many contracts, I'm thinking about my snowblower I bought for $1,100, one of the best days of my life, because I'm older than most of you in the class, and I was a little kid, but I did live through the blizzard of 78, and I thought I had a big, weird, hilly driveway. Everybody in my neighborhood either had a plow truck come to their home or they had snowblowers, and my father actually didn't even have snow shovels. We had dirt digging shovels with the point on the front, and they were beveled. And I'm still need therapy or medication over the horror of the winter of 78 shoveling for days on end. And so that sounds really silly, but I don't know, it was like maybe 5 years ago, I bought my first snowblower on my own for my own home. Even though I had a home before that, I just never had a snowblower. And I remember how excited I was. It was a big deal to me. It was $1,100, and it was a nice snowblower. I'm very happy with it. It's a weird thing. That's a great day in your life buying a snowblower. But I never signed a contract with it. I went in and I went with cash, and I bought it, and we never wrote anything down. There was a receipt that I wanted for purposes of warranty, because that's a later chapter. Maybe there might be something defective about it and it breaks too early, or it's not supposed to do what it's supposed to do. I might have a right to return it. But other than that, was it enforceable against me? No, it wasn't, but we executed the deal. He took the cash. He gave me the physical item, and it was a movable object, a snowblower, and therefore we don't care about the lack of a written agreement. Why? Because it was executed. But what if I went in there and it says, I like the snowblower, $1,200. Will you take $1,100? Well, it's on sale, actually, sir. You can get it for $1,100. I say, you got yourself a deal. I'll be back tomorrow. We never write anything down. If I don't come back tomorrow, can you sue me for damages or loss? No. But what if I do come back tomorrow and I say, I'm here to get my snowblower, and they say, no, we're not going to go forward. We sold it to somebody else. We don't have it. I said, yeah, but we had a deal. We had a contract. We had an oral acceptance of an offer. It was a meeting of the minds. We're both competent. It was for a legal purpose. And right away, they can cite that next issue. It wasn't in the right form. It wasn't in a written form. You can't bind us for that. There's going to be some exceptions in later chapters, but right now, for purpose of this, goods over $500 need to be reduced to writing to be enforceable. Sometimes I use cars as examples, but why that's a bad example is in order to transfer title to a car, there's a title document, and so that usually ends up becoming incorporated as the writing between the parties. You should always have a bill of sale. I don't know if it's in this chapter, but at one point we'll be talking about that when it's related to goods. Bill of sales for higher end products that cost such a great deal of money. It's nice to get a bill of sale, not so much because it's required. Bills of sales are not required in most circumstances. But why do you want to have one if you're the purchaser, or even if you're the seller? If questions of ownership come about or questions of warranty come about later, you want some kind of memorial as to what was paid for and when and for what. What if you get accused of, like, hey, Corman, you must have stole that laptop? He goes, no, I bought it from my friend. The password was password, and he had some stuff on it, but there was no documents. It says, no, it wasn't. He stole it. You have to return it to the rightful owner. Now, you're going to be charged with receiving stolen goods. We don't think you stole it, but we think this other guy did, and you bought it from him. You're in receipt of stolen goods. We're going to charge you with a crime. The defense to receiving stolen good is knowledge. I didn't know it was stolen. How do I prove it wasn't stolen? I have a bill of sales. It looks like I bought it legitimately, a reasonable fee related to it. So you do want to use a bill of sale if you can. So it's a kind of an easy chapter in the sense that these are the types of contracts that must be in writing to be enforceable. Again, my legs. Marriage, contracts for more than a year by their very terms. Land, anything related to the ownership of an interest in land. E is the executor's promise for the debts or the contracts of a decedent. The big one, goods over $500. And the last one, the reason why I didn't mention it was it's pretty obscure. It's called the Surety Ship. This is where you're becoming responsible for someone else's debt. Let's say I have a business entity out there that I do transactional work with, and I said, geez, I need so many steel rods, a ball bearing, whatever, something from the company. And they said, geez, we can't get any new raw materials right now because we owe a bunch of debt to the Acme the Acme metal supply company, and they won't give us any more product until we pay our debt. And what if I called them and I said, hey, I'm really wealthy, I got a bigger business in town, but I really like working with a smaller company. And I call the creditor and I say, hey, look, I'll make good on their debt. I'll be a guarantor for them or a surety ship for them if they should fail to pay and those money's due next month. Free up some of those raw materials for them so they can get me some ball bearings. That would only be enforceable against me if it was reduced to writing. And that makes sense. Once you become co-signer for children's loans, when they go to school, or, my kid bought a car and I co-signed for my daughter's loan at one time years ago when she got her first car. And it's scary because if she doesn't pay, I paid. But she actually paid off. She was responsible the whole time. But things happen. Things fall through. And so the point is why did that creditor want my name on it? Because I was a surety ship. I'm a backup for them. And you can see, why should I be held liable or responsible unless I showed my true intent by writing it down? It's too right for somebody arguing fraudulently that Jim, who had the deeper pockets and the wealth, promised to make good on their children's debts. So that's a surety ship. So that's my legs. That's it in a nutshell. Sometimes you can have a contract that's a little bit thin in terms of the material in there, but if it references other writings and say, this incorporates our understanding and, a memorandum attached here too, or a memorandum held, as long as we can figure out what documents you're referencing, they become incorporated and are part of the writing anyways. Not that big a deal for the question, but this next one is a huge issue I want you to know about, and I'll probably have a couple test questions on the next test. It's called the parole evidence rule. Parole means oral. I don't know why they call it the oral evidence rule, and they want to confuse us to make things sound more fancy, but over time you get it. It's one of those things, and I know when I was new to studying, sometimes it would really intimidate me, all this language, and I wouldn't feel smart because I didn't know what these people talk about. Don't be. It's just like learning a new language, and over time you'll get it. It's just a common sense provision in the law that says that if there's a contract in writing and it looks like all the terms are there between party A and party B, oral evidence cannot be used to bring in other added requirements of either party. Because that happens a lot. So what if, for example, I bought your house? I'm looking at it, you want $300,000 for it, I really like it, but you got two junk cars in the back on cinder blocks. And I say, you know what, I'll buy the house for $350,000. $350,000 would be quite a bargain. But I want those two junk cars removed. I don't know where to get rid of those. I wouldn't know how to get rid of them. Would you do that as part of the agreement? They say, sure. Then one day we're sitting down and we have our contract reduced to writing. And for whatever reason, there was no mention of removing those two cars. It was just the sale of the home and any improved buildings like sheds and things like that on the property, and that the property would be in the same condition as it was on the date of signing of the agreement. All of a sudden I go to get the house, and we clearly had agreed orally as a sort of side issue that those two cars would be removed. I get to the house, I get my keys, I'm all happy. It's moving in. They go in the backyard. There's two junk cars out there, and I'm furious. I go to court, sue you for the costs that I had to incur to get rid of those two vehicles. The defendant will just say, we had a written agreement for the purchase and sale of my home, and there was no side agreement in any written form about that aspect of conduct that was required between the two of us. Therefore, it's unenforceable. And I can't say, yeah, but we had an oral agreement. The court will literally not listen to me. They'll say, you have a written agreement that appears to be complete in its nature. We're not going to listen to side oral deals. Just as an oddball one back in the day, I don't think the registry does it anymore, but back in the day, you'd buy a car for $7,000. It was a lot of money back in the day for me. You'd not me, but I heard of people saying this. Hey, put in the written contract that it's for $2,000, so I won't have to pay as much sales tax at the registry of motor vehicles. And people would do that. What was the problem with that? Now you have a written contract for the purchase and sale of a motor vehicle for $2,000. Now what if I get home with the motor vehicle and it's leaking oil all over my driveway, and my friend looks at it and, it's got a blown head gasket, the thing's a piece of crap. You should sue them for some kind of either fraud, passive fraud, that they knew about this problem and they tricked me into buying it. They induced me saying it was a good engine, knowing full well it wasn't. Now when I go to sue them for the money, guess what the only thing I could sue them for? $2,000. Why not $7,000? Because the written contract is all that's going to be allowed to be used to show the understanding between the parties, because it looked complete in its nature, and you can't bring in all these other side agreements that supposedly modify or change. The exception to this rule, every rule has an exception, is sometimes we do have a written contract and we can tell what the parties' main objectives were going back and forth, so we're going to bind them. But there's some side issue that needs clarification, or there's a contradiction in the contract where on one part of the contract it says the painter shall have the job done by May 15th, but there's another part of the contract says it was June 15th. There seems to be a contradiction in the contract. So by definition, the parole evidence rule is you cannot bring in oral evidence if a contract appears to be clear and complete. Is that contract clear? No, it's not. It is complete enough to say the parties are bound, paint the house for $3,000. What's not clear is about when the parties actually had agreed to have the work done. Now oral evidence can be brought in to clear up this ambiguity, ambivalence, or missing information. That's the only time the parole evidence rule will allow oral evidence to come in. And I actually did some trial work on this. Every so often it would come up and you got this agreement, it's 20 pages long, there's all kinds of details in it. And somebody on the other side says, yeah, but he also agreed to do this other, major significant thing related to the contract. I'm like, where's in the contract? And sometimes as an attorney, I'm always surprised by that, where they say, oh, Jim, that was a side agreement. Okay, I'm not going to be able to prove that in court. I go, why not? It was a parole evidence rule. And then sometimes the attorney would do a little research and come back and goes, geez, you got me there. It's true. And same with my clients. I've had clients before. Yeah, I got this XYZ agreement. I'm looking at, where does it say they got to do this in the contract? Oh, it doesn't. That's a side thing. You can't. Everything's incorporated in what looks written here. It doesn't look incomplete. You can't add new information to modify, change, or add to what appears to be a complete written contract. And that's the parole evidence rule. I used to get that in real estate contracts a lot, landlord-tenant stuff. I used to do some of that. And every so often, the tenant would argue they had all kinds of things the landlord was supposed to do, and vice versa. Sometimes I had landlords say the tenant had all kinds of obligations to do things besides paying rent in terms of care and maintenance of the home. But if it wasn't part of the written lease, I'd argue the parole evidence rule bars any introduction of those side agreements. And I was usually pretty successful with that. Chapter's pretty straightforward. I went a little longer than I'd hoped, but I tend to run on, especially when I'm really tired like this. Chapter 12 is boring as heck. If I'm not too tired when I come home from Lowell tomorrow, I'll put that up. Again, I'm going to probably put this next test up on the Module 3. Please don't try to tackle it until you get some feedback on your homework. And don't be afraid. There's no such thing as a stupid question or an issue with regard to our class. So don't be afraid to give me a shout-out, text, email, call, anything at all. I'd be glad to talk to you, especially if you've sent me something and I missed it. And I've been notorious for that from time to time. I'm here to help, and I really want you to reach out and tell me that, an issue with some test. Every so often students say, I meant to put this on the test and it didn't read right. We'll make it right. We'll make it be as a responsive a class as we can. So don't be afraid to be redundant in requesting things if I don't seem to get back to you soon enough. Otherwise, be well, and we'll see you soon.